number 24 and 25, I know some personal difficulties. Can it be after 3 weeks?
Three weeks,
3 weeks,
24 and 25.
24.
On the prayer of Mr. Deepak, learn the concept of the petitioners, list this matter after 3 weeks.
Problem.
My Lord, I'd like to mention item number 4,
Hmm.
to take instruction whether substance exists or not.
Hmm?
To take instruction whether substance exists or not, therefore 1 week time may be given, my Lord.
Item number 4.
4,
What do you want?
1 week time to take instruction.
Why?
Uh,
You are
w-
for petitioner.
Yes, on behalf of M. Kato,
What instruction?
whether substance exists or not.
On the prayer of Mr. Emmett, learned counsel appearing on behalf of Mr. M. Kato. List this matter after
After 1 week.
a week, so as to enable the learned counsel to obtain instruction as to whether there is
Substance-
any lab issue to be adjudicated upon.
Item number 9 to my Lord,
9.
for filing affidavit. 2 weeks
9 is
on behalf of M. Kato.
no. Why you want to file reply?
Affidavit, to
Reply.
file affidavit, yes, reply to the
Who has
contrary.
filed? They have filed the affidavit.
Yes, my Lord.
Then same order, but then you just write Emmett, learned counsel appearing on behalf of Mr. M. Kato, learned counsel for the petitioner. Press for and is granted 2 weeks time to file affidavit in reply to the affidavit in opposition filed by the state. Sure, are you sure?
Yes,
You want to file a reply
yes, my
to the affidavit of opposition filed by the
Yes, ma'am.
state?
And my Lord, item number 12 too.
12.
Yes,
12 is what?
12 is on behalf of M. Kato, DSGI.
Young you minutes. You have
Will-
consent.
Consent, my Lord. I'm told consent taken.
I'm for respondent, Your Lordship.
Mr. Emmett is showing, sir, learned counsel appearing on behalf of Mr.
Yes. for filing.
Press for.
For affidavit, Your Lordship.
For affidavit.
Press for and granted 3 weeks time
3
to
weeks.
file affidavit in opposition. Have you filed?
Yes,
State,
yes, we have filed.
it is informed that it is informed by it is submitted by MS Arbasar, London State Council, that the state has the affidavit in opposition on behalf of the state has already been filed. List after 3 weeks. 3 weeks.
May I please, Lordship? Lordship, I beg to mention item number 13, 14, and 15
Yes.
on behalf of Mr. P.D. Nair.
What is this?
My lord, this is pertaining to greenfield compensation,
Hmm.
and also your lordship cannot take up this one
Okay.
because that the high power committee, you are one of the member
Okay.
for finalizing the rate.
This one.
Yes, 13,
Okay.
14, 15, right?
13, 14, 15.
List these matters before under
Yeah,
On 7, a fixed date.
No.
without me.
Lordship cannot take up. So fixing is the
Obligation.
I thought I'll dispose it of today.
My lord, I would like to mention item number 22. We are filing wakalatnama today, my lord, on behalf of the contender number 1.
It's with item 21.
21 and 22 are connected matters, my lord.
You are for?
The contender number 1, ADC.
You are appearing for alleged contempt of number 1.
Yes, sir.
You want to file affidavit.
Yes, today I am filing.
How many respondents? Okay. AGC notice has been served on other contempt. Wait for your turn, we'll see. It's in orders. This is listed for orders, we'll see. Wait for your turn.
Okay.
Yes.
And here I refer to file application and I did not receive a terabyte comment. This matter will be after 3 weeks. Madam.
5,
5, 10 and 11.
why?
Madam, the terabyte comment I sought for matter, I did not receive the
This is termination.
Madam, yes, termination. 5 is discontinuation, madam, because of lack of fund. And then 11 is termination, madam, legal account.
You've taken the consent
Yes, ma'am.
on the prayer of Mr. T. Tagum, Learned Standing Council for Education Department. List this matter after 3 weeks. So as to enable the Learned Standing Council to file affidavit in opposition on behalf of the state.
And my lord,
List after 3 weeks.
and also
Separate orders, item 5, item 10 and 11.
Also, a better method number 18, madam. Here, madam, we are filing affidavit today, madam.
We'll see. Let it be called orders.
My lordship, I
Yes.
beg to mention item number 6 and 7.
No adjournment.
The main council is out of session. due
I'll
to
hear
COVID.
you. You are good, Amit. Give the file. Do you have the brief?
Yes, sir.
Do you have the brief?
No, sir.
Take it from second file.
May I please, Your Lordship?
Yes,
I beg to mention item 23.
23.
23, Lordship. I
Virtually
no, Lordship.
all
Can
adjourned.
it be taken up tomorrow, Lordship? I did not
Or
want,
we may have tomorrow. We have enough time today.
Lordship, I did not want to say this, but actually, that Monigong Pokso case in which Monigong Pokso case,
Ah,
which this honorable court had taken sumo cognizance of. I was appointed as a legal aid counsel, and today it is up for final argument. So, I would,
what do you want now, in fact?
can it be taken up tomorrow,
No,
Lordship?
no, what do you want?
At
now?
least for the purpose of his promotion was not even regularized at the time of his thing.
But you have been
Retirement.
promoted now to the higher post,
I was promoted on officiating basis,
not regular.
not regularized. Lordship. So,
You have already retired.
yes, I retired last month. Lordship, can it be kindly taken up tomorrow, Lord?
Could have
Otherwise, I would not have made this prayer, Lordship.
retrospective promotion,
Yes,
notional.
yes.
If notional is given, what benefit you will get?
At least for the purpose of his pension.
Only for that.
Yes, Lordship.
But facts are very, very lengthy.
Yes, but the issue is very small.
Yeah.
Facts are lengthy, but the issue is very small.
Tomorrow,
Yes, Lordship. Oblige.
on the prayer of MS N. Dangan, learned counsel for the petitioner, list this matter for hearing tomorrow, I 04/09/2024.
Much obliged.
May I please, Your Honor?
Yes, what is the order?
Senior advocate is engaged in another court number 1. Your Honor.
Okay,
It may be,
you tell us what is this?
it may be pass over for some time, Your Honor.
At best, we'll issue a notice. What is the order? Heard MS
D Riba,
D.
D Riba.
D. Riva, learned counsel for the petitioner. This is an application under section 12 of the Contempt of Act, Contempt of Court Act 1971. Read with section Article 2215 of the Constitution of India. No, and Contempt of the Court Act 1971. Read with Contempt of the Courts within bracket Guwahati High Court Rules 1917. Alleging willful disobedience and non-compliance of the interim order dated 19/08/2024, passed in WPC number 339 of 2024. Issue notice returnable by 3 weeks. The learned counsel for the petitioner to take steps for service of notice upon respondent 1 and 2 by registered post with AD within 2 days from today, list after 3 weeks.
Much obliged, Your Honor.
May I please, Your Lordship?
Yes, madam.
Transfer, Lordship.
Yes.
The petitioner is a project coordinator. He is a contractual employee working under Mission Director, Swachh Bharat Mission,
Hmm.
PHE in Alo.
Yes.
As per the transfer order is at page 25.
Yes.
Now, Lordship may see his appointment order.
Age
Appointment order is page 18.
18,
Lordship, no, this is selection order.
23.
Yes,
Upon this.
page 21.
have
then
to
the
work
terms
in
and conditions.
Any place in West Siang district where the department is having
Yes,
establishment.
yes. These type of employees, they are contractual employees. They're appointed only for the purpose of a particular district. There's
Under what rule?
there is no such rule, but it's evident from the appointment order itself. Then this is also because the nature of the duty is such that they are supposed to give some sort of they are supposed to explain the SBM mission to the villagers in local dialect. That is why knowledge of local dialect is required for this kind of post. So,
Where it is?
Lordship. In one of the walk-in into, this is of course with regard to Teju district, but the qualification, it is, this is almost the same. This is page 30, Lordship. Page 30 is actually the type copy. Page 29 is the actual copy. This is a interview, walk-in interview public notification. Terms and conditions, Lordship will see. Preferences will be given to candidates having experience of working in Arunachal Pradesh with working knowledge of local language dialects. And the salary that they're getting, initially they got only 5,000 rupees. Now it is only 15,000 rupees. With such a meager salary.
Why you have been transferred? You are a disabled person also.
Yes, Lordship. I'm told that it is on the behest of the local MLA, but since I do not have the UO note, I have not enclosed it.
You didn't vote for him or what? Who is the local MLA?
I'm Mechuka. I'm sure the other person also would not like to come because he is a person from Longding. It will be difficult for him to even work in West Siang district because of the nature of the duties.
And MS Ndangan, London Council for the petitioner. By filing this application, the petitioner has put to challenge the, where is that?
Transfer order, Lordship? Page 20,
Put to challenge the
25. 13 August 24.
Transfer order dated 13/08/2024. Whoever the petitioner is sought to be transferred from Mechuka Division, Mechuka PHE and WS Division to the Office of the Executive Engineer, PHE and WS Division, Longding, as Block Coordinator, Vice Sri Tirian Ketok, Block Coordinator. MS N. Duncan, Learned Counsel for the petitioner, contended that the petitioner has been appointed as coordinator, a block coordinator under PHE and WS division, on contract basis, initially at a consolidated fixed pay of ₹5,000, and subsequently it has been raised to fixed pay
15,000.
of 15,000.
15,000.
List of the terms of the appointment clearly provides that the block coordinator, the petitioner on appointment block coordinator has to work in any where the department is having such. Accordingly, the petitioner was at Mechuka
Division.
Mechuka Division,
Yes.
Mechuka PHE and WS Division. List of. This is appointment is for 1 year.
It's extendable. Every year is extended.
The petitioner was appointed. Please no, the petitioner was appointed for 1 year. His service has been extended from to time, and agent that he's working in the same capacity. He's serving in the same capacity. Mr. MS and Duncan Learned Counsel further submits that since the nature of the job which the petitioner is performing as block coordinator is as such that it requires a knowledge of local dialect to explain to the local people about the programs or schemes.
Programs, schemes.
Programs, public schemes of the government. That apart, she submits that the petitioner is what is it? 75%?
Disabled. Visual impairment.
Okay. The petitioner is a disabled person having the visual impairment with 75% impairment in his right eye. Therefore, she submits that if the petitioner was working as block coordinator on such a bigger fixed salary, disabled person, is transferred from transfer from the present posting to a long link, a great hardship shall be caused to the petitioner. Therefore, he submits that this court may be pleased to interfere with the impugned transfer order dated 13/08/2024. Have you made any statement that is at the behest of?
Yes, I have met,
Before
but-
that, huh? Before that.
but I have not made him a
Just
party.
before the last two lines, two sentences, you just. Furthermore, the MS so and so. The MS Endang and Learned Council submits that there's no public interest involved. As the transfer order has been issued at the behest of the local MLA, Mr. Then you just add the two lines. Yes, madam.
Your Lordship, on an appointment, the petitioner have to work in any place in the district, which does not mean that he cannot be transferred any other place, Your Lordship, any other district.
Absolutely right. That is
Yes, Your Lordship.
what my view is also.
And Your Lordship, as per the appointment order 28 August 2012, there is no restriction that the petitioner cannot transfer out from Alo Division West Siang District, Your Lordship. And further, Your Lordship, the petitioner has already served more than 12 years in a particular division. Hence, there is no wrong in the transfer order. And also, Your Lordship, as per normal transfer and posting guideline, Your Lordship, adopted by the government, 2 years in a particular place of posting, Your Lordship.
To him,
And yes, actually, yes, it's a contract appointment, Your Lordship. And Your
Okay,
Lordship,
okay.
the order is vice versa, Your Lordship.
People London State Council submits that the condition the terms and condition provided to the effect that the petitioner has to work in any place in the West Siang district where the department is having such establishment, does not mean that the petitioner cannot be transferred to other place other than the West Siang district. Mr. She submits that since the petitioner was appointed on 28/08/2012 and has been serving at Mechuka, he has completed his normal tenure. Therefore, the impugned order has been issued. Impugned order dated 13/08/2024 has been issued in the interest of in the interest of government work. Next page. Issue notice returnable by 4 weeks. List of as MSP Pangolan State Council has entered appearance and effectively submitted effectively made her submissions defending the impugned transfer order, no formal notice need be issued. However, extra copies be furnished to the Learned Council for the respondent. Respondent
1 and 2, Your Lordship.
1 and 2.
Private respondents also there, Your Lordship.
Whatever, oh, sorry. For this extra copies, The learned counsel for the petitioner shall take steps for service of notice upon respondent number 3 by registered post with AG so and so, huh? Consider the submissions of the learned counsel for the parties. On interim prayer. Next prayer. Considering the, no, having considered that the petitioner is a contract employee who is working as a block coordinator under PHE and WSO division. Having disability with 75% impairment,
Visual impairment,
huh?
visual impairment.
Visual impairment. Come in the interim, the impugn order dated
13/8/24.
13/8/24 shall remain suspended till the disposal of this writ petition.
Obliged.
Mayor, please.
Yes, sir.
My lord, I'm challenging the legality and validity of impugn order passed by the deputy commissioner in a capacity of my lord appellate authority under section 12 of Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act. My lord,
Heard Mr. H. Learned counsel for the petitioner. The petition agreed by the order dated which 27/8.
yes, ma'am.
27/8/2024 passed by the Deputy Commissioner Capital, Itanagar. Whereby, where is that?
My lord, face solicited.
Whereby the extra assistant commissioner, Itanagar, has been directed to seal the unauthorized building construction of construction of the petitioner within 7 days from the order until further order. The present petition has been filed. You are constructing a building.
Yes, Lord.
My lord. My lord, I
You are
not,
constructing a building near the government quarter.
yes, my lord.
Why?
My lord,
You have the allotment.
yes, my lord. It is not my claim that this land belongs to me, my lord.
Then
My lord, the submission
how
of,
can you construct?
yes, my lord,
If land is not yours.
yes, my lord, submission of the petitioner is that, my lord. My lord, he was allotted with this quarter since 1983, my lord. He is occupation since 1983, my lord. Thereafter, he was retired on 2023, my lord. And this quarter has been allotted to his brother-in-law, who is living with him. He is also a government employee, my lord. Since, my lord, the family of the petitioner become large, my lord, they have, my lord, made constructed one, my lord, house, my lord. It's 12 by 10 feet only, my lord, for accommodation of the family, my lord. Otherwise, there is no any encroachment, my lord. And they are not claiming that this land belongs to me, my lord. Only submission, that is also submitted before the.
Don't construct.
No, construction is already done, my lord. It's just 12 by 10 feet only, my lord.
That's what you don't go for further construction. It said
Yes, ma'am.
directed to seal the unauthorized building.
Yes, my lord. We will not further construct, my lord.
Okay. Seal the unauthorized building construction.
And lots of direction has been given to the ESC, not to the petitioner directly. Deputy Commissioner, the appellant.
Obviously-
Appellant authority has.
Obviously, he'll be affected if
Of
his
course,
building
Lordship.
is sealed.
And Lordship, if your Lordship come to page 18, Lordship. Here, Lordship, the art cutting between my quarter and the respondent have complained to the Director Housing, Lordship. Quarter number 13 has.
We'll suspend this order because according to him, unless there's the eviction, the notice for eviction and all this still.
Yes, my lord.
Proceedings are on.
Yes, my lord. Until and unless there is, my lord, order passed by state officer under 5, 6, 7, and 8, and 10, my lord.
There's no order as such.
Yes, yes, ma'am.
So in view of that, because of that provision, we'll stay this, but we'll make it clear that you should not construct. No
Yes, Lordship.
construction.
Lordship, but then-
No further construction.
Yes. The estate officer has heard both the petitioner and the respondent, Lordship.
Hmm?
The hearing has taken place, Lordship.
Any order has been passed.
Yes,
My lord,
yes.
page 21.
Page
Kindly,
21.
kindly, page 21, ma'am.
And Lordship, in the complaint.
This is an
application-
appeal or what?
This is appeal, my lord. Appeal under
Appeal.
section 12 of the act, my lord.
Yes.
Yes, then
Page 21 is, my lord, this is order passed by additional deputy commissioner, come state officer. And in, by this order, I have been directed to construct a, my lord, protection wall as an interim measure only. Since there is complaint that because of art cutting, there is the quarter number 12, which is adjacent to the petitioner quarter, is
issue
in-
notice returnable by 4 weeks.
Pillar has capsized, Lordship, the other.
my lord,
persons,
I am
respondents,
complying with
pillar
that
has-
order, my lord, order of this ADC also, my lord.
MSG at the London additional senior government advocate enters appearance on behalf of all the respondent,
Yes, Lordship.
all or is there private respondents? No, 1, 2, 3.
1, 2, 3, but private is there, my lord.
1, 2,
Complainant.
3. 1, 2, and 3.
1, 2, 3. 4 is private respondent.
List of no permanent notice need be served. Our extra copies be furnished to the learned constable. The learned constable petitioner to take its state for service upon respond number 4, huh? Register for so and so. The in the interim, it is provided that the impugn order that is 27/08/2024 shall remain state till the next returnable date. However, it is made clear that no construction shall be carried out by the petitioner over the disputed land, over the land. You are staying in the building.
Yes, my lord.
Are you still constructing?
No, my lord, I am not construction now, my lord.
You have already constructed.
Just is a small, my lord, a small room, my lord, only. Not a big building, my lord.
How many rooms?
1, 2, but 12 or 10,
1 or
Feet.
2?
2, 2.
Even if one,
Yes, my lord.
even if it one, if you have across the government land. Anyway, we'll see.
Yes, my lord.
We'll see, madam, next day.
Yes, Lordship, with other.
I think
court
this
orders,
might,
if-
by now, this might have already sealed. This after 3 weeks.
Obliged.
Item number 6 and 7.
Yes, madam.
Yes, Your Lordship, in this matter, the petitioner was staying in the land since 2000. He has given for regularization of his land allotment in 2011. in 2000, there was one notification from the government where it is clearly said in, it is in annexure P2. It's in page number 24 to 26.
Yes,
The type copy is in 25.
24 to,
26, type copy is in 25.
no, your petition is up to 28, page 28.
Your lordship, it's petition
Request
number
for
1.
temporary provision land allotment. Page
Ye-
29,
Yes, it's writ petition 163, your lordship.
163.
Yes. Your lordship.
Yes,
160, page number 25, type copy.
25.
Yes.
Hmm.
May I read?
Yes,
In subject, it's given regularization of all government land under occupation of private individuals, state and central government establishment and cabinet decision thereof. The body is a large number of cases of occupation of government land by private individuals, state and central government establishment, all states as well as in the capital complex have come to the notice of the government. The matter has reviewed by the cabinet in its meeting held on 2nd May 2012. The cabinet have taken this serious view of the such situation and directed to take following actions immediately. Point 1 is regularization of plots occupied by private individuals, state and central government establishment in time-bound manner in all districts, including capital complex, sorry, after proper survey and verification as per existing acts and rules and realization of land premium and lease rent from the date of occupation. All government land remaining unused under the occupation of central government agencies, corporation, central paramilitary forces and state government department located in various places in districts and outside the state be reverted back to the state government, which shall be taken over by the land management department. So till this time, the petitioners, this regularization representation was pending there. And after that, they haven't replied anything. And in the petitioner was in presumption that his application will be, his representation will be
yes.
disposed of in the DC office. But in 2002, suddenly there was notification while he was constructing. There was one complaint from private individual, not from the government. It from private individual. It is in the page number 38. It is in page number 36 to 37.
Yes.
So here, the private individual has complained for land encroachment. The person is the BJP party worker. So it is the political rivalry, not any like he is doing for good intention. So there was the intention that the petitioner is from the Congress party. So due to of the party rivalry, he have written this application, and still till now the petitioner's application is pending. So there is no reason that why his application is not
Consider.
yes. So the notification of government is very clear that he should have been given that, but till now it's pending. So we are, and if he won't get this allotment, then he won't have any land in the township.
Petitioner is a politician.
Not politician, just local leader. It's more local leader, and what he have constructed there is just his hard-earned money. From his hard-earned money, he have constructed
He's
that.
from Congress party.
Yes, your lordship.
Okay.
So it's
So complainant is a BJP.
yes, your lordship. It's very clearly mentioned in the letter.
District President Kisan Mohan. Yes.
So if it not considered, then also they should have been given the reason that why it's not considered, because the cabinet's decision is very clear that they have made this for the benefit of the people. And the petitioner is there, the land was in possession of petitioner till 2000, and he made the representation letter in 2011.
But the facts remain that it's a government land.
But yes, but it should have been considered because cabinet have made this decision maybe for the good of the people.
Way back in 2012.
Your
Then
lordship,
Is it still in force?
it said that during time bound, but time is not given, but his representation letter should have been considered because it was just within 1 year.
What is that impute order?
It's in page number 47 to 48.
Hmm?
47 to 48.
47.
Yes. And even your lordship, they are saying that this is a DRDA's property, but DRDA itself is saying that they are not concerned whether it's there or not.
So your appeal has also been
This one is-
rejected.
Yes, your lordship.
Where is that? Is hereby directed to proceed for enforcement, removal, escrow, or merchant produce eviction insurance. Where is that notice? Page 33.
Your lordship, it's.
What is page 33?
It might be. It's in 41 notice.
31, 33, page 33.
So he started constructing the structure there. So at that time, he got this notice.
Rejected.
Yes, Lord.
And one other one, 329.
It was for stay yourself.
For what?
For the
Against which order?
for encroachment of
This 140, the 41 notice? Page 41 notice.
Your Lordship, this was for stay of the construction, stay of the encroachment.
Stay of the enforcement.
329-1.
Which order?
There was interim pending here, so it's for that.
Why two petitions?
Actually, one was for the stay of the this
You have
eviction.
challenge in the 1263, 229, three orders.
Your Lordship, 329 is for the interim. For the interim.
What interim?
Stay for the stay
What
of
is
the
stay?
stay of the eviction.
Which order? Eviction of which order?
Page number 77, Your Lordship.
77.
It's in the writ petition 329.
16, 9, 2020. Yes. What about 6, 7, 2020, 22? Okay. So this, your reply was rejected by the ADC,
Yes,
State Officer on 16
yes, Your Lordship.
16 September 2022. And then in 120, 162, '22. Yes.
Lordship,
In 163, Your Lordship, the petitioner, he has challenged three orders. One show cause notice by the DC and two orders by the ADC, Your Lordship. May I kindly see, Your Lordship, 163, Your Lordship. A notice by the DC, page 33.
Is 33.
Yes,
Yes.
21st February 2022, Your Lordship. May I read, Your Lordship?
Hmm.
Whereas it has come to the notice of the undersigned that Sri Nyasum Jongsam of Rangkatu village has developed a site and started a construction work near Project Director DRDA Quarter Changlang without taking prior approval from the competent authority. Whereas in any kind of earth cutting or site development for construction of any structure without formal land allotment is violation of government order.
You stop construction work and then explain in the thing.
Yes.
Yes.
Yes, hence in view of above, Nyasam Johnson is directed to stop the construction immediately and explain in written to the undersigned as to why not
Next.
initiate. And next order was, Your Lordship, at page
He
41,
He filed a representation against that.
representation, Your Lordship. And another order which he was challenged is 8/3/2022 order, Your Lordship, page 41.
Hmm.
By the ADC, also estate officer. Whereas it has been brought to the notice of the undersigned that you are illegally encroaching the government land by developing a site and starting a construction work, dear Project Director Changlang, without obtaining prior approval. And whereas a preliminary notice was also served from this office dated 21/2/22 for stopping the construction work and seeking written explanation to the undersigned as to why the legal action should not be initiated against you. And whereas a written reply has been received from your end dated 24/2/2022, which is not found satisfactory by the competent authority. Hence, you are directed to vacate the encroached land by removing the unauthorized structure without 7 days from the date of issue, Your Lordship. And after that, also, Your Lordship, another order, 12/4/2022 order was issued, Your Lordship, page 47, Your Lordship. By the estate officer, Your Lordship.
Hmm.
Whereas it has come to the notice to understand that you have illegally occupied and started construction activities in government land near Project Director, whereas notice Y dated 8 March 2022 was issued to you under Section 6, Subsection 2 of Arunachal Pradesh Eviction and Unauthorized Occupancy Act 2023 for illegal occupying and undertaking construction activities in government land, whereas in the matter mentioned above, there was no proof submitted to establish your rights on the above mentioned land. Moreover, the land under question has already been allotted to the DRDA department as per cadastral record. There is ample evidence to prove the government ownership of the said land. Your explanation is therefore inadequate and unsatisfactory, Your Lordship. So here also, Your Lordship, he has been given 15 days to vacate the land, Your Lordship. Against these three orders, Your Lordship, he has filed this writ petition, Your Lordship. So on 28/4/2022, Your Lordship, the Honorable Court has stayed these three orders, Your Lordship, on 28/4/2022. But during the pendency of this writ petition, Your Lordship, Honorable Court has directed to initiate fresh proceeding against the petitioner in accordance with law. So fresh proceeding has initiated, Your Lordship. And against that fresh proceeding, Your Lordship, the petitioner has filed another this writ petition, Your Lordship.
What proceeding?
329, Your Lordship.
Where is the?
Notice was issued, Your Lordship, again. In,
No, where is that?
in 329 writ
No,
petition.
where is the direction to initiate this proceeding?
Lordship, order, in order 28/4/2022, Your Lordship, in order dated.
In this 163?
Yes, Your Lordship. Order dated 28/4/2022.
20?
28/4. 28 April 2022.
2024
28/4.
of 2024.
Yes, 2022, Your Lordship.
Okay.
28/4/2022. In 163 writ petition.
Fresh proceeding against the petitioner in accordance with law. Yes.
Yes.
Then,
And accordingly, Your Lordship, we have taken fresh proceedings against the petitioner, Your Lordship, and issued notice, Your Lordship, fresh notice dated 11/5/2022 to the petitioner, Your Lordship. Where we have given ample opportunity there also, Your Lordship, but he could not prove his case, Your Lordship, since the land is the government, Your Lordship. And as per record also, Your Lordship, we have annexed citadel register also, Your Lordship, to show that the land belongs to the DRDA department, and there's a quarter also, Your Lordship, there.
so what is the stage now?
This order has also been stayed, Your Lordship, by the court.
Huh?
Notice has been stayed, Your Lordship. And also, the petitioner was asked not to undertake any construction activities, Your Lordship.
What about this appeal? Appeal number 21. Agency has submitted report. Appeal is disposed of.
Yes, Your Lordship.
And then the 16th September is an eviction, is the first proceedings,
Yes, Your Lordship.
page 76. Then this has also been stayed.
Only, Your Lordship, order dated 16/9/22 has been stayed, Your Lordship.
16/9.
16/9 notice. Your Lordship.
Thereafter,
Appeal is also against the petitioner, Your Lordship.
where it is?
That's the-
16/9 is the last order,
16
eviction order.
Yes, 16/9 is the last order, Your Lordship.
This is by ADC.
ADC.
Any appeal against this?
Page 80, Your Lordship.
80.
Yes.
ADC is out of that.
ADC the 16/7. ADC, yes.
Seen an eviction order was by ADC. but
Yes.
listed for revision.
ADC has been approved.
Yes. No, this is of 2000. This is July.
Oh, this is July, Your Lordship. This is
After
against this order only, Your Lordship. The fresh proceedings, Your Lordship, this, he has come, Lordship.
Okay. Otherwise, first proceedings, the appeal has already been disposed of.
Yes, Your Lordship.
Is it this order initiating eviction or is it eviction order because of the court order or because of dismissal of the appeal?
No, it is not because of the court's order, Your Lordship.
Has rejected the appeal petition as per section 12 of so and so. Upon the section 5(1) of order so and so by order C to vacate the property. Yes. Yeah, yes. As per the statement of the Deputy Commissioner.
this land has been allotted to ERDA. There is in your para 6, 7, and 10. Thereafter, we were made as a respondent, as a party respondent 5 and 6 only. So this affidavit, Your Honor, is filed by our affidavit has been filed by respondent 5, project director, DRDA. Now, we were uncertain whether the land has been allotted to us or not. So we've made a communication to the district land revenue officer regarding the status of the land. Now my affidavit in opposition.
Yeah.
Now, this DRDA has given me a register, chitta register, indicating that DRDA has been allotted 855 square meter. Now, nowhere they have provided us with a map of the area. So we are uncertain whether the land has been allotted to us or not. Because the land which they have
So
constructed.
you are saying that you are not sure that this land falls under your allotted area.
Yes,
But this is says that it's
allotted to us. Yes, sir.
If you don't know whether,
Because we have not been provided with any map.
it's not a question of providing, you must know what is your land and how much area you have been allotted. It's your duty to find out.
Yes, sir. That's why we have communicated to the.
So you
Regularization.
after that only when you have been provided cheetah register, then you are happy. Even if you don't know that how much area whether this land encroached by the petitioner is within your allotted area or not.
As far it is not.
That. Yes, that case appears to be not allotted. Consider and allot him. Very strange. Department is why you are so, careless. This is allotted, not you, department.
Yes, sir. Yes. This is as per the affidavit.
That's what I'm saying. What affidavit is this?
Yes. Affidavit.
The government had allotted you a land to the department. You are not sure what is the area and how much area.
Yes. It is due to the reason during construction of his building.
It's your duty to find out. Department, it's allotted to you.
I have made a query and my PD says, my lord, it is not on the record, but my PD says this is the quarter, this side of the quarter, this side of the land has been allotted to us where there is a quarter and there is an alley. There is an alley upstairs for another department and the land is situated at this place and other side of the alley. So we cannot say about this place, this area.
What?
This
Other side of what?
Other side of the alley. Like for example, for instance, this is an alley. For going to Aquator, there are also another department where the quarter
In
has been
between the land which he has encroached.
Yes.
In your quarter.
Not in my quarter. Is opposite to my.
No, in between there is what?
Alley. A road, walking road.
Yeah.
So we are uncertain whether the land belongs to us or not.
He is supporting you.
Yes, Your Worship.
No, that is unofficial. It is not on the record.
Yes. What is to be done?
But Chitta register, Your Lordship, it is there. It is maintained by the land department, Your Lordship.
See, you have heard his submission.
Yes. This is the information provided to me.
But otherwise also, Your Lordship, even if it is not allotted to them, Your Lordship, it is a government land, Your Lordship. And the petitioner cannot construct anything, Your Lordship, without having any proper land allotment order, Your Lordship.
Heard MS. So and so, learn counsel for the petitioner. And also heard Who is number one?
My lord.
One and D come to London Standing Council for the Land Management Department. And
3 and 4, Your Lordship.
comma, MS. Two is who? Who is two?
1 and 2.
Yes. MS Arbasar, London State Council to respond number 3 and 4. You implemented as 5 and 6.
Yes, lord. I am for the 5 and 6.
And Mr. B. Pitcher for respondent 5 and 6. And standing council are the department. For respondent numbers 5 and 6. Next paragraph. Having regard to the similarity and the issue raised in these two writ petitions, comma, same are being taken up and disposed of by this common order. Next paragraph. The petitioner is agreed by the notice of that is 163. 163, what the last order is what? Is 47. What is that notice in 163? First is file 160, right?
Yes. First notice, page 33, Your Lordship.
33.
Yes.
Agreement of the notice dated 08/03/2022 and zero 07/04, right? 040,
Page 41, next order.
yes.
Page 41,
Oh.
8/3/2022. Page 41.
8/3/2020. 8/3/2022. And other one is
And 12/4/2022, page 47.
what about 7/4? What is 7/4? 7/4 is by the deputy commissioner.
Order dated. 7.
And 12/4/2022, page 47, issued by the ADC state official, Changna, whereby the petitioner has been directed to vacate and demolish the illegal structure within 15 days from the date of issue of notice. List of the petitioner is also agreed by the in 263, 329, what are the not
In 329, I am for respondent of 5 and 6, not in 169.
it's okay. 329, what are the notices, the impugn orders?
Impugn orders, page 76, Your Lordship. 16/9/2022.
76 only. 16 September.
16 September.
Sixteen 2022. Issued by the ADC State Officer. Janglang. Whereby the petitioner is directed to vacate the government plot illegally occupied by him.
Lordship, 6 July 2022 also, Your Lordship. Order passed.
All the illegal structures within 7 days from the date of issue of the order, dwelling which eviction drive will be carried out. Page 76, in writ petition 323. In fact, this 162,
163.
163, all these notices which were put to challenge is culminated into the order of this, in the challenge in the 329.
329. No, fresh proceedings notices only he has
Yes.
challenged.
If you started fresh proceedings,
Yes,
it goes automatically goes off.
yes, yes.
Yeah, in the orders which you have passed and put to challenge in 163, it goes.
It goes, Your Lordship. So order in what 329, Your Lordship. Order dated,
We'll have to consider 329 only.
yes, Your Lordship.
Although the various proceedings, including the notices, continue, by the responding authorities, by the state officer as well as deputy commissioner, Tanglang district, have been put to challenge in both the writ petitions. Essentially, the orders of the notice of eviction issued afresh by the ADC the state officer Changlang upon this the disposal of the appeal by the petitioner is the orders which is essentially being put to challenge. Next paragraph. The case in nutshell projected by the petitioner is that he is in possession of a land measuring approximately 500 square meters since 2000 in the Changlang Township, Changlang District, Arunachal Pradesh. The petitioner submitted an application for allotment of the said plot of land to the Deputy Commissioner on 22/11/2011. Have you given the description of the land?
In page number 29, Mav has given.
Changlang Township, how do you know?
She has not applied in a proper format also, Your Lordship, just a representation to the DC, Your Lordship.
According to the petitioner, he has applied for temporary oblique provisional land allotment of the said plot of land as per the Arunachal Pradesh Land Settlement and Records Act 2000 and the rules made thereunder. Particularly Section 12 of the Section 12 and Rule 134 of the said Act and rules. List.
Map is in page 31.
Yes.
Page 31.
Of what?
WPC 329. Proposed map.
This is by the petitioner, prepared by the petitioner,
Yes.
not by any officials from the Land Management Department. Next paragraph. However, continue. However, the respondent authorities has not considered the case of the petition. That is the contention of the petitioner that by notification dated 24/05/2012, the government has directed all the deputy commissioner of all the district in the state to consider the regulation of all the government occupied land by private individuals. The deputy commissioners and other officers, other concerned officers were particularly adhered to the instruction and ensured that the regulation work is done in a time-bound manner as per Arunachal Pradesh Land Settlement Records Act 2000. List of. Since the next one, it is contended that since the petitioner is in occupation of the land since 2000, occupation of the government land since 2000, by virtue of notification dated 24/05/2012, is entitled to be is entitled his land, his occupied land is to be regularized. However, instead of considering the case of the petitioner in terms of the notification and the various applications for regulation of the land, however, the ADC cum state officer has issued the impute notices for eviction from time to time. The petitioner, in terms of the Arunachal Pradesh lands, eviction of unauthorized so and so, 2003, eviction of unauthorized act 2003.
Yes.
You just get that full thing, title. So being aggrieved of the illegal action of the state officer by repeated notices for eviction, the petitioner has filed an appeal under section 12 against the action of notices or orders of the state officer. Even during the pendency of the appeal, when the further notices were issued, this court has approached, the petitioner has approached this court by a writ petition. Where is that writ petition which has been disposed of?
Lordship,
This court has disposed of the earlier writ petition. Where is that?
WPC 99 AP of 2022.
Where it is? You have annex somewhere
Uh,
in 163 or 323?
It's in 160 WPC 163 annexure 10.
Yes. Page. Page number,
Page
madam?
46.
46.
Yes, Your Lordship. WPC 163.
Being WPC 99 of
Yes, 99 of 2022.
2022. This court on 15/03/2022 has disposed of the writ petition within bracket supra bracket clause having found that the petitioner has filed an appeal under section 12 of the Arunachal Pradesh Public Premises within bracket Eviction of Unauthorized Occupants, 2000, Act 2003. And the same has not been disposed of by the authority. With the consent of the parties, with the direction that the appellate said, with the direction to dispose of the appeal filed by petitioner within the period of 1 month by a speaking order and in accordance with the law. Accordingly, in compliance of the order of this court, that it's 16, why is this 15 or 16? 15/03/2022. The Deputy Commissioner Changna has disposed of the appeal of the petitioner. Clearly, by rejecting the same, by dismissing the same on the ground that the construction undertaken by the petitioner is not legal and is a pure case of encroachment over the government land, public premises. Consequently, the state officer was directed to proceed for encroachment, for removal of such encroachment by the petitioner as per the Arunachal Pradesh Public Premises Eviction of Unauthorized so and so. When you mentioned it first, you just Act 2003 in short, in between initially. Other acts you don't have to, that 2000 law, it's okay. But in so far as it's, we're repeating it again and again, right? 2003 you just said, other this 2000 you don't have to do this. Then finally this, what is the latest one? 16/9.
6/7/2022 is the notice, Your Lordship. First
That's
notice.
okay. 16/9 is the final, last the notice.
Yes, last notice.
Thereafter, the the eviction order dated 16/09/2022 has been passed by the ADC cum state officer. Has been directed to vacate the government plot illegally occupied by him by removing all the illegal structure within 7 days from the date of issue of the order, failing which eviction shall be carried out. MS so-and-so learned counsel for the petitioner submits that though the petitioner has not though, submits that the petitioner has occupied the land since 2000. Thereafter, the government has taken a policy decision to regularize such possession oblique occupation of the government land by the private individuals by notification oblique letter issued directing the all the deputy commissioners in the state to adhere to the such policy and to regularize the government plot, regularize the occupation of the government plot by private individuals. However, the deputy commissioner as well as deputy commissioner has not acted, has failed to act in terms of the government notification, which accrued a right to the petitioner for regulation of his occupied government land. Mr. The responding authorities, particularly Deputy Commissioner and the ADC, State Officer of Changlang District, instead of complying with the government direction which has been taken by a policy decision from resorted to illegal orders of resorted to passing illegal orders of eviction one after another. So which compelled the petitioners to approach this court to protect the right of the petitioner for regulation of his and then for regulation of his occupied plot, government plot within Changlang Council. Therefore, she submits that the impugn actions of issuance of action of eviction orders dated 16/09/2022, as well as other consequential orders passed by the ADC, the state officer, as well as the deputy commissioners, deputy commissioner of Changlang district, maybe set aside and was, and also and maybe and a direction may be issued to the deputy commissioner Changlang to consider the case of the petitioner for regulation of his occupied plot of land in question in accordance with the what is that letter? Government notification?
It's in WPC 329, page number 33.
23.
Page number 33 to 35. Thirty-four is the type.
2023.
Yes, WPC 329.
It's not 329, 163. In terms of their government policy, which was informed to the deputy commissioner, all the deputy commissioners in the state by letter dated page 25, huh? That commission. It's not a notification as such. Dated 24/05/2012. MS Arbasar learned State Council appearing for respondent number 3 and 4. 3 and 4, comma. On the other, it submits that the petitioner has enforced the government land, which has been allotted to the Department of, allotted to DRDA. Allotted, na? According to you,
Yes, Your Lordship.
allotted to DRDA. Mr.
As per Chitta register, Your Lordship. Chitta register, Your
Chitta
Lordship.
register. Chitta register available in the record list. There is no dispute that the petitioner has occupied the land illegally. Though the petitioner has submitted some applications, but the application for allotment is not in a proper format. Mr. Over the government land, comma. He has no indefeasible right to be allotted the said land as the land and the next page. She submits that comma. The no. The state cabinet has taken a serious view of the large number of cases of occupation of government land by private individuals from a state and central government establishment in all districts and in the capital complex. And has decided to decided for regulation of plots occupied by the private individuals, state and central government established in a time-bound manner, including capital complex, after as per and to realize the land premium and lease rent from the date of occupation. It also provided for to return the remaining unused to the government. Decided to revert the unused government state government. This is the above policy was taken as a one-time measure, as there are serious, there were large number of cases of occupation of the government land by private individuals. Please stop. There is no record that there is nothing on record to show that the case of the petitioner is feasible for regulation in terms of the above decision of the cabinet decision. As the same was taken as a one-time measure to protect the government land. This too. Records reveals that it is only the land occupied, a plot occupied by petitioner is allotted to the DRDA. Therefore, as a matter of right, the petitioner cannot claim on the basis of the cabinet decision, which was taken in the interest of protecting the government land vis-a-vis the private, in the occupation of the private individual over the government land as a one-time measure. Next minute. She submits that the action of the deputy commissioner as well as the state officer in passing the impugn orders is in accordance with the law, as undisputedly the petitioner is illegally occupying the government land by and also by constructing the structures over the said land. Yes. Therefore, she submits that no relief can be granted to the petitioner. Next panel. Mr. B. Picha, learned counsel for the standing counsel for respondent number 5 and 6.
Yes.
Submits that though as per cheater register, it appears to have been allotted to the
Yes, ma'am.
cheater register. What does it reflect?
It says DRD has been allotted 855 square meter.
As per cheater register, it reflects that an area of approximately 800 square meter.
855 square meters
850 square meters have been allotted to DRDA
for quarter.
for quarters. However, there is nothing on record to show that the present plot of land is occupied by the under the occupation of the petitioner falls under the said allotted area of the department.
And that, in that regard, also we have earlier also filed an we have communicated to the deputy commissioner, page 84.
The department has communicated to the
12 July 2021
to the deputy commissioner from time to time
for proper demarcation of
proper demarcation and clarification
DRD and Panchayat Raj
of the land allotted to the petitioner, land allotted to the department.
and Panchayat Raj Development,
However, no demarcation.
or no demand.
However, there is no demarcation has been carried out as on date. Therefore, he submits that the department is not clear whether the land occupied by the petitioner falls under the allotted area to the department.
DRDA.
Obliged. What I should record?
No, my lord,
What is your view? You have nothing to say.
nothing to effect. But
What about this policy of the government, 2012, for regulation of occupation by the private individual?
it was for just a particular specific
Particular period.
yeah.
Next para. Mr. D. Kamduk Laran, Standing Council for Land Management, submits that the policy of the state upon a decision by the state cabinet dated 05/02/2012 was a one-time measure considering the rampant encroachment and occupation of the government land. Therefore, the policy which was taken for a particular period as a one-time measure, considering the public interest involved vis-a-vis the occupation and encroachment of the government, the private individuals over the government land, cannot be a basis for any individual to claim regularization of the illegal occupation of the government land. Please.
Lordship, I would like to point out one thing, Your Lordship. While passing the appeal order, Your Lordship, the DC has observed that DDMO, Your Lordship, he has submitted his verification that the said land is not suitable for construction, Your Lordship. It may trigger landslide, thus disrupting to public safety. This has been
So in that case, you consider allot him to his own risk.
we have stated in our affidavit also, Your Lordship. that
It's not feasible for allot.
It is not feasible.
It's a landslide.
Landslide area, Your Lordship.
Landslide prone area.
Yes, Your Lordship.
But that will be again contradictory. You said that it is allotted to the DRDA.
But quarter is not constructed on that land, Your Lordship, though it is under the occupation of the DDR.
We're dismissing it,
Lordship.
but will direct you to consider if, in view of the fact that they are not sure, the department which you have allotted, they are not sure, they are not interested. You consider this case in accordance with law.
Lordship.
We'll just provide that.
After proper verification, demarcation.
Due consideration has been extended the submission of the learned counsel for the parties and also peruse the materials available in the court. Next para. Uncontrovertibly, come on, the petitioner is in the occupation of the occupation of the plot of land, measuring approximately 200 square meter,
It's 500 square.
500 square meter, which is a government land. Please stop. It is also not disputed that the petitioner has filed an application for regularization of the said plot of land. though it is not in a proper format. Next page. Considering the State Cabinet on 02/05/2012 has taken a decision upon taking serious view of large number occupation of government land by private individuals, etc. To regularize all the government land under occupation of private individuals, state and central government establishment. Pursuant to the Commissioner within bracket Land Management, Government of Arunachal Pradesh, by letter dated 24/05/2012, addressed to all the deputy commissioner, additional deputy commissioner within the state, to for regulation of the plots occupied by the private individuals, etc., in a time-bound manner in all the districts, including the capital complex. After proper survey and verification, as per the existing acts and rules, Mr. It is also provided that all the deputy commissioner, additional deputy commissioner, land settlement and land revenue and settlement officers, to adhere to the instruction and ensure that the regulation work is done in time-bound manner, as per the Arunachal Pradesh within bracket Land Settlement Records Act 2000. Next page. The copy of the letter dated 24/05/2012 is reproduced here in below, page 25 of 163, right? On the bare perusal of the above letter indicates that goes to show that the state has decided to regularize the plots occupied by the private individuals in a time-bound manner, and as per the existing act and rules. The decision appears to have been taken as a one-time measure, as there were serious encroachment and occupation of the government land by private individuals, state and central government establishment, in all the district and in as well as in the capital. Considering that the state had a policy in 2012, maybe a one-time appear, the authorities ought to have abide by the policy of the state at the relevant point of time. In the present case, nothing is discernible from the records. Either the petitioner, either the respondent authorities have made any attempt to consider the case of the petitioner in accordance with and as per the policy of the state. Dated 02/05/2012. At the same time, the petitioner has not been able to establish any right over the over the land which he is in occupation, as the land in question admittedly is a government land. It is purely the prerogative of the government whether to allot any individual, to allot the government land to any private individuals or establishment. The allotment of the government land is guided by certain set of procedures which is provided under the acts and rules. In my considered view, no individual, in my considered view, no individual can claim any indefeasible right for allotment of the government land. Just merely on the basis that, merely on the ground that he has occupied the government land since so many years. The policy, of the state, the policy of the state, has noted about, appears to be a one-time measure to tide up the encroachment of the illegal occupation, considering the fact situation at the relevant point of time. Therefore, same cannot be a ground for any individual to claim for regularization of the allotment on the basis of such policy. Next page. So, the petitioner, the learned counsel of the petitioner has made her best effort to establish that the land in question occupied by the petition since 2000 deserve to be considered for allotment. Either as a bona fide citizen as a bona fide citizen in consonance with the policy decision taken in the policy decision of the state. Comma. I'm on the considered be the no. Come on. Such effort by the learned considerable is considered duly been considered is duly considered, but only for rejection, as the petitioner cannot have any indefeasible right to claim for allotment of the regulation of the land. However, since the record doesn't reveals however, from the records, it is not discernible that the respondent authority has considered the case of the petitioner, except the action of issuing the impugned orders on the ground that the petitioner has enforced and illegally occupied the land. Come on. It is to be made by the authorities. Of the various proceedings of notices of eviction and the consequential I find that no serious infraction of the required provisions of Act and rules have been committed by the state respondents. Thus, I'm of the view that there's no reason to interfere with the proceedings undertaken by state respondents, as it appears to have followed the appears to have followed the required provisions of the acts and rules, at least the last impugned order dated, what is that? 16/09/2024. Expect. In view of the above discussions and conclusion made here in above. I'm of the considered view that no interference is called for to the action of the respondent authorities in passing the impugn orders. Was into the proceedings of eviction as the same has been issued in accordance with the requirement of the provisions of the Act and rules. Mr. As no relief can be granted to the petitioner. Next paragraph. Consequently, the writ petitions stands dismissed accordingly. Mr. Next paragraph. However, the dismissal of the writ petition shall not preclude the Deputy Commissioner to reconsider the case of the petitioner. To consider the case of the petitioner, taking into consideration of the fact that the case of the petition appears to have been not considered when the policy of the state was in vogue. The consideration shall be needless to say, needlessly observe that the consideration, if any, of the case of the petition shall be strictly in accordance with the law. Sorry, madam, you have tried.
सीधा लिखिएगा नहीं हो जाएगा क्या क्या होता है आए क्या आए से चेक कर लेना आए क्या
I number, I 70.
The affidavit in opposition.
We
For the
we have
respondent.
not received the instruction, Your Lordship. At least some more time may be needed, 4 weeks, Your Lordship.
Want to dismiss and you are asking for a. Or
They may
Mr.
be given some time.
Or Mr.
Fine.
T. Sunil. You want that they should be given a time.
Yes.
Sunil, learned counsel for the petitioner. I thought I'll dispose of this matter today. 1 week. MSP Pango, learned counsel, state counsel is granted a fresh spot and is granted 2 weeks time to file affidavit. Mr. You have anything to say?
No, my lord.
D. Kamlu, learned counsel. The learned standing counsel, land management department is present.
In this regard, I was supposed to file rejoinder. Rejoinder petition is ready. It will be filing within 3 days. In this case, I'm supposed to file rejoinder.
That's
Rejoinder
all.
petition is ready and it will be filed.
Mr.
Within-
Learned counsel for the petitioner. Praise for it is granted
1 week time.
1 week time to file affidavit. MS P. Pango learned state counsel is present.
Obliged, most obliged.
Yes.
In this case, I have filed an application to add the present incumbent as a party, because in the meantime,
Huh?
during pendency of this content proceeding, the chairman was transferred, new chairman has joined. I want the new chairman to be made as a party. To that extent, I have filed an IA. That may be considered and new chairman may be added as a party.
This is,
My lord,
you have complied with.
No,
we have proposed,
no, well, they have
This-
proposed, they have
let
made a
me,
proposal before this one report. In one letter, in another letter, this was before it, that is how this.
Yes, yes.
my lord, white communication dated, that is at page 3. That it was initial proposal.
Pastry, this one.
Yes, oh,
Yeah.
next. After-
No, from this.
Yes,
Yes.
so this was our initial proposal. Then on this call has asked, directed us to file a affidavit.
Hmm.
So here in this proposal, column, serial number 7, this is the loan which we have taken. In the remark itself, it clearly indicates that these are the total loan amount, 4,75,280. Then interest will be up to that interest as per rate applicable will be charged and total outstanding along with interest thereon will be recovered from the arrear payment. Then we have filed affidavit, additional affidavit with annexing this page 4 order dated 19/7/2024. So as per the calculation, that is loan part,
Yes.
principal amount along with the interest, it comes to 11,45,688 has to be recovered from the petitioner. And upper part, that is regarding aerial salary and commutation, that comes around 1 crore. That we have proposed to pay it in a 4 installment. And gratuity at 19 lakhs we have already released. Then monthly pension for 1 month already released. Now arrear pension payable 18 lakhs 93 already released. And the first installment payment of rupees 19 lakhs 30,000 will be transferred to his account by 30/9/2024 onwards till 36/2025. This is our proposal. So then after this court again directed us to clarify how this figure change. This is the first phase is the clarification.
first page of today's instruction. So there, here we have explained in earlier instruction, it clearly indicates principal amount is 4,75,000. Now, in last occasion, my learned friend said that there is change of figures. So we have given the principal amount only, not the interest. Now, in principal plus interest is 11,45,000, which is recovered from. This will recover in during the payment of the installment, the area salary.
11 lakhs.
11,45,000. Now he is getting more than 1 crore rupees. This is our proposal. So I would like this.
Letter dated 27th June, they came with a proposal. In that, they say principal amount is 4.75 something. That was also on record. Now they are coming with the principal, which is 10 lakhs. That is how, in the last of this directed, you explain how the principal can be from 470, it was escalated up nearing to 10 lakhs. Will also kindly see the second table at paragraph 2 of the present today's document. What it says? It says present outstanding, that means principal.
Which one?
Today's paragraph 2, table in paragraph 2.
First page.
First page. It says present loan outstanding, that means this is the principal. Then interest. If interest is in second column and the first column is principal, how the first column will be double?
You have availed the loan.
During my tenure, when I was serving, I have availed the loan.
For how much?
There are 5 loans. They say it is there.
1, 2, 3.
Different amounts.
The total principal amount is 4,75,000.
475.
Yes.
But today they are saying it is 10,000.
No, if you avail this much, this is the principal. What they are saying is they have not calculated the interest.
What this
You have availed the loan. Forget about.
There is no.
They avail the loan. Then you have to return with the required interest.
I am not on the point. I am not. They have to take from my areas.
Yeah.
But what is that amount? They cannot.
They have calculated it. It has
That
been
calculation.
explained.
I have challenged that calculation.
Figures submitted are only principal outstanding.
Second column of both the tables. Second column of the both the tables.
I don't think there is any confusion.
Yes, there is no confusion.
Yeah.
See, you must be knowing how much amount you have availed. There is no dispute.
On the point of
There is no dispute. 4,75,280.
Yeah. Yes.
In where? When? When?
During my tenure.
During your tenure, which year?
It is there.
Different years.
Yes, different.
Anyway,
Page 5 is
there is no dispute to it.
no that
Principal amount.
that principal.
And so far as the applicable rates are concerned of the interest, you cannot say that I should not be charged with interest. Have you availed the loan without interest? Have you paid it within a time prescribed limit?
No, because of their mistake, I was unable to
It's
pay.
all right. You have to
Because
pay.
of their mistake. No, I am ready to pay. They have to recover.
Yes.
But they cannot recover.
There's no if and buts. This is principal amount is
Principal
4,75,000.
They are varying in the principal amount.
And
itself.
on the principal amount, they have calculated the present loan outstanding, the notional interest up to so and so total amount to be recovered.
I am liable to pay the notional interest. There is no doubt on this.
Then
I am disputing the figures in column number 2 and figures in column number 2 in both the tables. You'll also kindly see it is very much available. That is how this oracle wanted to explain why this is variation.
why? This is 475 is the principal amount.
Yes, now the principal.
Then column 2 is interest with all.
No, this is not interest, is the next part. Interest comes to 133. They have calculated. They have calculated interest in the second column, notional interest up to 28 January 22. This is interest.
220.
Different loan, there are 5 loans. They are in.
Principal amount, here the principal amount comes to 991. That is how this one.
We'll dispose of this application. You should miscase. Miscase is there.
Miscase I am fine from the present chairman as a part.
It has been added, allowed,
No, I have filed application.
where it is. I will allow this implement chairman.
My submission, if my lord is, this matter may be disposed of since.
No, it's a contempt proceedings.
Content proceeding.
We'll see into it. Today, this is fixed for here only.
Okay,
Do you have any objection for implement
no
of the
objection.
present chairman? Heard Mr. So-and-so, learned counsel for deputy, and also heard Mr. G. Tarak, learned counsel for the Alice Contempner. By filing this application, the applicant has prayed for implement of one Sri Hoggin Hakim, present chairman of what
Arunachal
Arunachal Pradesh
Pradesh Rural Bank.
Rural Bank as the earlier chairman, Mr. Deepak Gupta, has already transferred or retired, transferred. Plus two. Mr. G. Tarak has no objection for implement, has no objection to the application, present application as one Sri Hogan Hakim has joined as a chairman in the Arunachal Pradesh Rural Bank. Arunachal Pradesh Rural Bank.
Rural Bank.
Itanagar.
Naharlan.
Naharlagun. Yes. Having considered the submissions and the fact that the one Sri and also the fact that the also on the fact that the one Sri Hogan Hakim has joined as a chairman in Arunachal Pradesh Rural Bank, Naharlagun, in place of the respondent number 1. I deem it appropriate to allow the application. Accordingly, the Sri Hogan Hakim be implemented at respondent number 3 in the connected contempt petition. You write application for implement of so-and-so in the connected contempt petition. Contempt petition. Contempt case number within bracket C of C5 of 2023. Initially also, at the beginning also. The IA stands allowed and disposed of. Next paragraph. In view of the order passed in ISO and so in contempt, the learned counsel for the petitioner is directed to file, is allowed to file amended course title.
Only cost of plan.
Amended course title within 2 days. Please do. On filing of the amended course title, the registry to issue notice to the newly implemented respondent number 3. You said implemented respondent number 3 so and so. So this is, are you agreeable to the proposal?
Proposal, they cannot.
What is the violation?
Violation is not so kindly see the total figure. In the second.
In the result, the writ petition allowed by setting is a report of disinbursement and the consequent order from this imposed upon in view of the setting in this which is in response to certain notices within a period of 3 months from and not the being played with the statement of no distinction proceeding by the response. Again, if the same is permissible under the law. Who has passed this out there? Don't
simple submission.
Don't complicate.
No, I'm not complicating.
So
They are
here
com-
maybe the authority Alice contempt, they might not have completed within 3 months. They might have not settled the issues.
No, I have not. They have given me a proposal. You are to accept it or not.
Yes.
You have to accept their proposal, and that is second aspect. But what they are proposing here, which is related to the loan amount, I am disputing because they have not purposeful. They are not giving the figures. You also kindly see the there are two tables. Column one.
You file an appeal. I am dismissing your this contempt petition. What is this here? The court has directed to settle your retired benefits. That's all. It has not been done within 3 months. You have filed a contempt petition. They come up with proposal because the retired benefits is the issue. But you have availed a loan.
I'm not disputing about my loan. But
If you are not disputing, what's the problem?
problem is they are taking interest twice. You know, kindly say that is how I am.
Which one?
Column 2 and column 3. What is column? They have table 2. You also kindly see. Just
What?
have
What table 2?
Table 2.
Yes.
Table paragraph 2. The first is the
The
loan
following
tax.
details, updated figures, including interest charges applicable, were submitted to Honorable
Yes.
Court. Yes.
First column is with regard to nature of the loans. Principal are showing 9 lakhs 91 some odd.
Which one?
Second column.
9 lakhs?
Their total figure they have not given. That is how I am committing. They have not given in the past they have given total figure for 75.
Which one? Which one?
Here they have not seen the total figure. Total figure it comes 991.
We can calculate.
In the earlier table it is 475.
You are saying that this table 1 and table 2 doesn't match.
Yes.
Huh?
Basically column number 2. Column number 2, if that is the principal, that should be fixed in both the cases. Here they have shown the final figure is 475. Here the final figure they did not, which I have calculated 9 lakhs 91 some odd. Even figures are also can check from the loan wise. Excepting loan number 1, all 4 loan figures are changed.
Forget about the figures. According to you, these are the loans which you have availed.
I have availed loans.
Which one? Column table 1 or table 2?
Table 1 is correct figure. Table 2 they are saying this figure is not correct.
Suppose, according to you, if these are if the applicable rate of interest and charges are
They have calculated.
if calculated, what is the figure according to you? Is it 1145 or something like?
1145 cannot be.
Why?
If principal is 475, interest is this much. The third column they have calculated. It is their calculation. Third column you can see. On the same first page. Second
My
table.
lord, if he have any issue, then he can go to the office and he can raise the objection there.
This be recovered. We submit here details of CBS system generated figures to substitute the loan outstanding figure amount to 1 lakh submitted to loan in there is no any figures mentioned here. Yes.
No, principal cannot vary. My submission is principal cannot vary. They have.
I don't know whether
You
it
have,
is
you have settled everything. Have you settled?
now 19 lakhs plus 18 lakhs already settled.
You tell us what is according to you, what is the exact what would be the figure? If you are saying you are admitting this, forget about column 2 and column 1.
470.
475 to 80.
470. Yes. This is.
These are the loan you have available.
Yes.
Is that it?
On this they have to calculate the interest.
That we don't know how to calculate.
Outstanding without interest.
Let the petitioner go to office and see the records. Then if he have found any irregularities, then he can
So
come up.
when did you avail these loans?
During
Different
I was
years.
suspended in 2009. That is prior to 2009.
It's 15 years.
Yes.
15 years. Right? More than a 15 years. So according to you, what is your calculation?
That is a fee.
That is what is your according to what should be the interest?
For each loan there is a contract. Contractual rate is applicable. Contractual rate in the loan is applicable. So various loans, various.
That is not an issue here. This is contempt proceedings.
They have to settle my dues. They cannot,
Settle dues what?
they have to recover my loan amount with applicable interest. Principal amount they are escalating. That is whole problem. That is how this whole
You
directed.
tell us what is the applicable, I mean, the amount which you are supposed to pay on the interest.
I am
Calculate and give us.
4/7. I am liable to pay interest on.
What is the interest on
Interest-
475?
When interest is variable because on each loan there is a separate.
Mister, tell us what according to what would be the figure?
Each
They have calculated 1145. What is your calculation?
1145 is not correct figure.
I'm not asking. I'm not saying whether it is correct or not correct. I'm asking according to what would be the figure?
The figure is to be different. On each loan there is different figure. Because loan is even different rates, different contractual rate are applicable.
I'm not hearing you. We'll hear him and we'll pass the order. What is this here?
Well,
I ask you simple question.
well,
You are saying they have calculated exaggerated amount, the interest, which comes up to 11 just wait, 11 lakhs 45,000.
this-
I'm asking according to your calculation, what would be the amount?
For that, I will take some time. to-
Then you say that I'm asking you since last 15 minutes.
I'm taking some time, also give some time so that I make a calculation and submit.
Very unfortunate. What is this? Are you agreeing to the proposals?
The proposal, I have filed my reply. I object to the proposal. They cannot.
So is there any violation? Is there any violation? What is the nature of your objection? You are just disputing the interest part.
Yes.
You are not saying that it has not been settled. There is no contempt.
They cannot recover arbitrarily. Today they are saying your principal.
It's not the question of arbitrary requirement. What do you mean by arbitrary?
Today, if they are.
What today?
Well,
I have asked you a simple question. You are just unnecessary.
It is their own document. Two documents are filed, two figures are given.
Don't be try to be over smart. I'm asking you a simple question. Can't you calculate what would be the interest according to you?
In each land, I will calculate with a figure.
Heard, Mister. I'm closing it. We'll give you a liberty to approach the responding authorities. It's a simple, dispute on the calculation of the interest. I'm asking what is, according to you, what is the rates? What is your calculation? You are not able to give any calculation, simply saying that it cannot be.
No,
They have calculated. They may be wrong in calculation. You point out. You calculate and say this would be the. You are not disputing the loan which you have availed.
No, loan amount I have never disputed.
Then
Even
you simply calculate on it.
I will calculate
With the applicable rate.
Sometimes so that I will calculate each loan wise and give.
But that is not to be the issue taken up in this proceedings, contempt proceedings, right? List after a week, will you come up? Well, it's a contempt proceedings. You know, it's not, this court is not exercising a rate jurisdiction. Please listen first. This is a contempt proceedings. It's not, this court is not exercising a writ jurisdiction. We'll have to see whether there is a compliance or that too, whether there is a willful disobedience or not. That we'll have to see. That's all. But then we're giving you, allowing to, leniently allowing you to, allowed your indulgence. Your duty technically is to brought before this court the violation, alleged violation. Thereafter, it's between the court and the alleged contemptor. You don't have any role to play. And the submission you are making is not related to the proceedings at all. Simple, well, if you find that there is a violation, we'll issue contempt notice. That's all. Why are you trying to establish the dispute? Why you are trying to establish a disputed fact in the contempt proceedings? You appears to be senior enough. Where are you from?
I am from Delhi.
Delhi. That's the problem.
No, I mean, I am trying to assist.
This court was also in Delhi for more than 6 years.
I am
That
not-
is the whole problem. Don't take it otherwise.
No, no, I am not.
If you are from Delhi, you must know better than, you must better know what is the contempt proceedings.
That is how I am not making any submission.
Then don't make a submission.
My entire thing will not be kindly.
What entire thing? It's a contempt proceeding.
Last-
Listen, Mr. Listen, it's a contempt proceedings. Do you know?
I don't.
Do you have any idea about what is the contempt proceedings?
I don't have
It's
any
just
pro-
because you got a degree and started practicing, it's not enough. I'm sorry. I was trying to cooperate.
You know, I have tried.
Instead of you cooperate with the court, assisting the court, this court was doing just the reverse. I asked you a simple question so that the person should get the relief, even if he's not entitled under this in these proceedings. We're trying to help you out. Just such type of practice will ruin your litigants.
I tried to convince my lord.
I'll pass an order that you should not. We don't require your assistance. And man has retired. He's yet to receive the retirement benefits. You are playing with your litigants, client. What is this? We cannot brush it. We cannot shut our eyes.
I'm sorry.
Who plays the lawyer plays with
I
the
failed to assist
with
my-
with the luck? I mean the life of the litigants. We're here for litigants, the common citizen, not the lawyer for a lawyer or somebody from the state capital, the country's capital. You cannot take for granted. Be careful next time.
I'm sorry.
We're listing it after 1 week, and you don't have to appear. Since you are coming from the Delhi, it will be a burden for the client who is yet to receive his retirement benefit. And there is no requirement of assistance also. It's very simple. We'll see whether there is a violation, that to disobedience, willful disobedience or not. That's all. Sorry.
I'm sorry.
Listen
If
up to-
if I failed to assist my
Always.
lords, I'm sorry for this. And the lordship may if we can date be fixed so that.
Fix it after a week. But don't burden your client.
Item number 18. If it can be, may I pray, can it be VC?
26?
Next date, can I appeal to VC?
After 1 week fixing, we're closing it. Let the client get his benefits. The authorities, they'll take it, the advantage of pendency of this contempt petition. Nothing will come out. Rather, it will be against the interest of your client. The pendency of the contempt proceedings will rather be against the interest of your client. Because there is no willful disobedience at all. But it will dispose it of. If any dispute is there, will allow you to raise before that. That is also not permissible technically in a strict sense. Next week, after a week, just fix the date. Just give the date. You take the date from them. We want you to visit the estate. It's a beautiful estate. But then not at the cost of having that attitude in the before the court. You welcome.
Pray my
What's your name? What's your name?
Gautam Bhol.
Gautam
Bhol.
Ball. I think you are appearing for the second time or third time before this court.
Yeah.
Second time.
No. I think 10 to 15 times I have appeared.
Appeared before me. Before this court,
This court,
before this court.
before this one, I 4-5 times. I mean, but may I pray the next day I will appear through BC.
That too I will not allow. You file an appeal against that. BC, you know, it's very difficult. Even in physical, you are not able to say anything. You are not able to assist anything. How you will assist through the BC? You don't have to. It's a contempt proceeding. You are not supposed. What is your role? You have brought before us. We'll see. Next week, then give the date. It's up to you. And we're fixing it for the interest of your client, litigants, not for the benefits of the lawyer. Ultimately, it is for the clients only, litigants only. Yes.
My lord, yet they filed the counter affidavit.
When? What? How much?
We have already
Mr.
filed,
Sons,
madam.
learned
We have
counsel for
already-
the- Huh?
They have already filed their counter affidavit today.
Yes.
So we'll receive the affidavit and if needed, we will file a reply on that.
Heard Mr. So-and-so learned counsel for the petition. Mr. T. Tagum, learned standing counsel,
Yes, madam, education department.
education department. Has submitted that he has already filed the filed affidavit in opposition on behalf of the state. Mr. So-and-so learned counsel. Yes, sir.
Yes, sir.
Press for some time to go through the affidavit of opposition. If need be, he would file affidavit in reply. Yes. Accordingly.
My lord. My lord, I'm appearing for private respondent.
So and so, huh? You are filing affidavit.
Yes. and-
You have filed.
No, I need some more time.
Mr. So and so, appears for private respondent number so and so, huh? Considering the submission of the consequent parts, let this matter be listed after 3 weeks. 3 weeks.
There is an interim.
Interim order plus alias will continue.
Deeply obliged.
Item number 19 and 20.
Yes. On the prayer of.
Your Lordship, actually here the
IA is what? IA is for what?
IA is for interim stay of the.
You have to file objection.
Yes.
Heard Mr. MS so learning consequent. IA, you want to file objection IA?
Actually, Your Lordship, if this IA will stay for long, maybe the compensation will disperse and petitioner will deprive of the compensation. That's the issue.
What is the issue?
It's for the compensation.
But we'll have to establish. We'll have to help that you are entitled to compensation. Then we'll go for stay.
Then it will be.
MS K. Wangbo, London State Council, prays for and is granted 3 weeks time to 2 weeks. 3 weeks time to file affidavit. List after 3 weeks. Somebody, yes, you made a mention.
Yes, my lord. I made a mention.
Mention for what?
Actually,
You want to file reply?
no, my lord, actually, I had mentioned for adjournment.
Yes, that's right. Why adjournment?
Actually, Your Honor, the petition is not yet ready, so we need some more time to submit.
Petition is not ready.
I mean, my lord, the affidavit in opposition.
You are for petitioner.
No, respondent
Respondent.
number,
Heard Mr. B. Taipodia, learned counsel for the petitioner. Mr. Your name, please?
D. Doyang.
D. Ronya.
D. Doyang.
Goya.
Doyang.
D. Goya, learned counsel appearing on behalf of respondent number 1. Prays for and is granted 3 weeks time to file affidavit in opposition. MSP Pango, learned.
For respondent number 1, Your Lordship.
Huh? He is also respondent number 1.
Item 21, Your Lordship.
Your Honor, in contempt, he is 1.
My lord,
I mean, big petition.
In
Contempt petition, my lord.
Contempt petition, huh? Respondent number one. And same MS so for respondent number one in writ petition so huh? You are also asking for,
No, Your Lordship.
you
we
have filed
already-
the affidavit.
Yes, we have already filed our counter affidavit.
List after 3 weeks.
Your Honor, interim may be continued.
Interim order plus alias shall continue.
Obliged.